just some introductions and administrative information, and then we can get started with the presentation. For those that haven't met me, my name is Jan Pietrusca. I'm the head of the Labor and Employment Group for Shumaker's Tampa office. Brief introduction on Shumaker to the extent you need one. Shumaker is a business law firm. We pride ourselves on doing everything that a business might need. We have offices here in Florida, Ohio, North Carolina, South Carolina, and Michigan. As you can imagine, and as I'm sure all of you have been, we've been very busy during this coronavirus process. All of our groups are pumping out information to clients to try to help them through this. Raul or Katie, if you could go to the next slide. We're trying not to overwhelm clients with information and provide them the information they need, but you've probably received from us client alerts by email. If you're not, go ahead and shoot me an email and I'll get you on distribution lists as needed. But you can also go, we've got a dedicated coronavirus resource page. The link is here, Client Resource Center. All the information that we are publishing, every client alert is posted there. It's not just labor and employment, it's tax, it's healthcare, it's real estate, it's force majeure, it's PPP. I think on average are publishing maybe 2 client alerts a day. So again, we're trying not to overwhelm your inbox and trying not to send every client alert to every client, but you can always check this web page and they're all posted there the day they go up. Also, for I think it's more than a month now, we have had a coronavirus hotline. It is a 24/7 hotline manned by Shumaker attorneys. We realized that clients were very busy during the day and they were having legal problems and needed help after hours. So you can call the number there. It'll be answered 24 hours a day by a Shumaker attorney who will either be able to answer your question or put you in touch with attorneys that can. We here at the Labor and Employment Group have been very busy trying to help clients through all the issues they've been dealing with, and we're going to touch on a lot of them today. The sad part is this is normally the time of year where we're all getting together. For those that are new, or this is your first introduction to us, we normally put on twice a year free seminars for our clients on labor and employment issues. We dedicate a morning to going in depth on 3 sort of topics and doing some Q&A afterwards. We miss all of you. We miss seeing you. We'll be back together again soon. But in the meantime, welcome to Shumaker's first virtual webinar for the Labor and Employment Group. I think we've got a really good presentation for you. We changed the format up a little bit just because there seem to be so many different topics we wanted to touch on. And so we're going to do a short 10-minute presentation on 5 different topics. We're going to try to give you the bare bones information of things you need to be on the lookout for, common issues or problems that we're seeing clients run into, or some practical advice, things you can be doing in these areas. We've then dedicated about 40 minutes at the end to answer pre-submitted questions. We received a lot. We are going to do our best to get through all of them. I can stay for a little bit past the 3:30 deadline. I've got a call at 4 o'clock, but I'll stay on as long as I can. We understand everyone's busy, so to the extent you need to drop off, none of us will be offended. But again, we're going to work through as many of these questions as we can. Just looking through my notes here. HR and SHRM credit. We always try to get these webinars approved for HR, SHRM credit, and CLE. We have applied and the HR and SHRM credit is pending. If you need that, please shoot an email to the rsvp@shumaker.com. Again, it's just rsvp@shumaker.com, and let them know you need that. And when we get approved, we will send that to you. We've got a really good presentation. As I said, we're going to do 5 topics really quick. Chris Cavalieri is going to lead it off, talking about the new Families First Leave Act. Brad DeBobian will follow him and talk about furlough, pay reductions, and layoff issues. I'm going to be in the middle talking about the WARN Act. John Burgess will follow me to talk about employee benefits issues with coronavirus, and then Mark Connolly is going to present on unemployment issues. Additionally, a lot of you submitted SBA or PPP loan questions. Shumaker has built a dedicated team of 25 to 30 attorneys that are working all day helping clients figure out these loans, figure out how to maximize them, how to use the forgiveness provisions. And since we got so many questions, we're also joined by Jan Pitchford and Jack Santinello, two of our partners that are on that team. So they will be available for some of the questions at the end. As always, we're always trying to improve this process. And so I do invite feedback from you as to this format, any way we can improve it for future virtual webinars, topics you want to hear about. You can email those to me, or if you want them confidential, you can send them to rsvp@shumaker.com and they'll pass the comment, but not the sender along to me. So the last thing is I referenced those client alerts and invitations. If you're not on Shumaker's labor and employment distribution list, please just email me and I'll get you on it. You'll know if you're on it if you've got an invite from me for this webinar. If you want to be on it and you didn't receive an email from me, just shoot me an email and I will add you to the distribution list. So with that, we'll go ahead and get started. If everyone, again, can mute your lines to the extent you haven't done so. And Chris, if you can take it away.
Thanks, Jan. Good afternoon, everybody. Again, my name is Chris Cavalieri. I am an attorney here in the employment law group in our Tampa office, or in today's case, my den. I am here to kick things off for you this afternoon to talk about the paid leave laws under the Families First Coronavirus Response Act, or Relief Act, it should say. That's FFCRA. So with no further ado, let's get into our first topic because I have a lot to cover and not a lot of time. What is it? What is this law? What is the paid leave that we are required to provide? I am assuming that most, if not all of you on this webinar today are already probably familiar with the basics, if not a lot of the detail. So I am going to give a very, very quick refresher on this. So what is it? This law says that if you have under 500 employees, you are required to provide 2 types of leave if your employee cannot work or telework because of various coronavirus related reasons. So let's get specific. What are those 2 types of leave? Number 1, paid sick leave. This requires you to provide the equivalent of 2 weeks worth of paid leave for 6 different types of coronavirus related reasons when an employee can't work or telework. What are those 6 reasons? Number 1, they're subject to a government quarantine order. Think shelter at home, stay at home. Number 2, they're advised by their doctor or ordered by their doctor to self-quarantine. Number 3, they've got symptoms of coronavirus and they're seeking a medical diagnosis. Number 4, they're caring for someone who is subject to a government or a doctor quarantine order. Number 4, they've got what I'll call throughout this today childcare issues. They have to care for a child whose school is closed, whose place of care is closed, whose child care provider is unavailable. And number 6, the weird one that no one knows anything about yet, the employee has a substantially similar condition that has not been defined yet. I will really not spend any time on that. The pay that an employee is entitled to receive during this 2-week period depends on the reason that they're taking leave. It's either 100% of their pay for the first 3 reasons that I went over, or 2/3 of their pay for the following 3 reasons. That's the first type of paid leave that we're required to provide under the FFCRA. The second type of paid leave is what I'll call the expanded FMLA. Again, this applies as long as you have under 500 employees, with one additional requirement, and that requirement is that the employee needs to have worked for you for at least 30 days. That 30-day requirement is not in the paid sick leave part, okay? So that only applies to the expanded FMLA. Now, unlike the paid sick leave law that covers various types of coronavirus related reasons, You're only required to provide expanded FMLA leave if your employee has childcare issues. And that is those reasons that I went over before. Their child's school is closed, their childcare provider is unavailable, the place of care is closed. How much leave do we have to provide under the expanded FMLA? Just like regular FMLA, it's 12 weeks of leave. The first 2 weeks of those 12 weeks are unpaid, but, and that's a big but, the employee can choose if they want to use their paid sick leave during those first 2 weeks or any other leave that they might have through your policies that would otherwise cover childcare reasons such as PTO. They can choose to use that leave during those first 2 weeks. They cannot be required to do so. And then those remaining 10 weeks are paid at 2/3 of their normal regular rate. One caveat to both of the paid leave requirements that I just went over: if you employ healthcare providers or emergency responders, you can elect to exempt yourself and not provide leave to healthcare providers or emergency responders. Again, that is a very quick refresher. We've got client alerts on this. Please get with me offline if you need more detail, but we're going to be covering a lot of the detail during the Q&A session. Moving on to the second topic, how do I claim the small business exemption? This is a little bit of a trick question. I did that on purpose. I personally, and I think that the rest of us will agree, and they can chime in if they don't, I personally do not see this as a blanket exemption that you can claim with anybody. What the small business exemption allows you to do is to deny leave to a particular employee when certain conditions exist. So, what is required for you to make use of this small business exemption? Several requirements. Number one, you have to have under 50 employees. Number two, the reason that the employee is requesting leave has to be for childcare related reasons. What does that mean? That means that if the employee is experiencing symptoms of coronavirus, or if they're subject to a doctor's order, etc., this small business exemption does not apply. It only applies for childcare related reasons. Number three, and this is very important, an authorized officer of the company needs to make a determination that one of three conditions exists or would exist if the company were to provide the person leave. What are those three conditions? Number one, the officer needs to determine that if I provided leave to this person, the company's expenses would exceed its revenues and it could not operate at a minimal capacity. That's a hard threshold to meet, especially considering the fact that you are eligible for tax credits on the leave that you're required to provide. Condition number two, the employee has such specialized skills or knowledge of the business that to lose them based on leave would essentially crush the business, okay? Condition number three, the position that the employee fills is necessary for the business and the company can't find qualified workers to fill it. Now, whether that means the company can't find qualified workers from within the company or whether it can't find qualified workers in the general marketplace, who knows? The DOL has not really provided us guidance on that, and sort of that's anybody's guess at this point. But the officer needs to make a determination that one of those three conditions exist. Finally, the final requirement to claim the small business exemption is that you have to document the reason for denying the request. What do I mean by that? I mean that the officer needs to document which of those conditions applies. How would you do that? I'd recommend that you use a standard form. And literally, the form would say, we are denying your request for leave because one of these conditions exist, and the authorized officer would literally check the box. We have a form that you can use. Please get with me offline. We can provide it to you for very, very minimal cost. Do this every single time you're going to deny a request based on the small business exemption. Finally, my final note on this topic, consult with counsel before you deny anyone's request, because if we don't do this properly, we are just walking into a potential discrimination claim or retaliation claim. Moving on to the third topic, what do I need to do now? Meaning, I haven't gotten a request from an employee for leave under the statute. Am I required to do anything at all? And the answer is yes. The one thing that I'm aware of that you have to do right now, if you haven't done it already, is put up the Department of Labor's required poster for the Families First Coronavirus Relief Act. This poster requirement applies even if you're a small business and you're going to claim the small business exemption that we just discussed, even if you're going to deny a healthcare provider's request for leave, all employers under 500 employees have to put up this poster. You have to put it up in the same place that you would put up your other workplace posters, in a conspicuous place where everyone can see it. Chris, what the heck do I do if all of my employees are working from home? You can comply with this requirement by emailing this poster. If you want a copy of this poster, get with me offline. I can send you a link to the Department of Labor's poster. What can I do to prepare? We've talked about what do I need to do now. What can I do to prepare? Here are some practical tips. Number one, if you don't already have an FFCRA or a coronavirus leave policy, now might be the time to consider putting one in place. You don't necessarily need to distribute this to all of your employees. If for any other reason, I would recommend that you have an FFCRA policy in place, at least for internal purposes, so that your HR department knows to implement this leave required under law in a standard uniform fashion. It could help you avoid potential unequal implementation claims, discrimination claims, right? We have these policies and are happy to help you prepare them, to tailor them for your business. What's another thing I can do to prepare? We have been recommending to our clients, wherever possible, that if you can shift your workforce to working remotely, if at all possible, try to do it. And why is that? That's because this FFCRA only requires you to provide paid leave when your employee cannot work or telework. That means that if your employee can work from home, you're not required to provide the paid leave. So we've been recommending to our clients, wherever possible, try to transition your employees to working from home. It could prevent you from having to provide a lot of paid leave. If you're going to do that, or if you already have employees working from home, and if you don't already have a telecommuting or a work from home policy, now is certainly the time to do it. These telecommuting policies establish the rules for working from home. It could allow you to approve of the workplace, of the workspace at home, to avoid potential workers' compensation claims. It would address how they can use technology from home. Very important to have when you have employees working from home. What else can I do to prepare? If you'd like to know what employees in your workplace might pose risks to your other employees, you might consider putting in place an employee health questionnaire. This is a questionnaire that your employee would sign at the beginning of every day or at the beginning of every work shift, attesting to whether they have experienced symptoms of coronavirus since their last work day, whether they've been in direct close contact with someone who has. This can allow you to detect employees to, first of all, kick off the work site immediately, and second of all, to detect employees who might be in need of leave. Finally, a topic that it's not always comfortable to talk about. If you haven't done so already, now is also the time to consider potentially reducing the hours of employees who have not already requested leave, furloughing employees, laying employees off. The regulations do make clear that furloughed employees and employees who have been laid off are not entitled to leave. My final topic, what do I need to do when an employee requests leave? Let's get into some practical advice here. This is very important. Regardless of whether you're going to grant or deny an employee's request for leave, you are required to document very specific information. What is that information? I'm going to tell you how to do it in a second. That information is, you got to document the person's name, the dates that they've requested leave, the reason that they've requested leave, and depending on the reason that they've requested leave, the regulations say you have to document additional information. For example, if someone says they need leave because they're subject to a doctor's order telling them to self-quarantine, you're required to document the name of the doctor. If they're saying that they're required to self-quarantine because of a government order, you're required to document the name of the government entity, like Hillsborough County, that has required them to self-quarantine. If they're saying that they need to take care of their children because their school or place of care is closed, you're required to document the name of the child, the age of the child, the name of the school, and a statement from the employee certifying that no other suitable person is available to take care of that child. How do you do that? We have a request form that we recommend our clients use. You would use it the same every single time. It's a standard form that your employee would fill out requesting either paid sick leave or expanded FMLA. They would literally check the box for the reason why and provide the other information that you're required to obtain. The other thing that you're required to do when you get a request for leave is you have to get a statement from the employee certifying certain things. For example, the statement needs to certify that they're unable to work or telework because of the reason that they're requesting leave. They also have to provide additional information, like I just said, for example, the name of the children, the name of the school, etc. Again, we have a standard form. I'm happy to provide it to you at very, very minimal cost. Just contact me after the webinar. Finally, what do I need to do when an employee requests leave? You have to maintain these records for 4 years. Keep in mind, folks, it's not just important to get this documentation because the laws require it. It's also very important to maintain this documentation because you need it in order to claim the tax credits. And if you don't have that documentation, you're not going to be able to get the tax credits. With that, that is a very, very high level overview. We're going to be addressing more details in the Q&A session. Thank you everybody for your time, and I'll address the details later.
Good afternoon, everybody. My name is Brad DeBovian, and I am a partner in the Labor and Employment Practice Group of Shumaker's Tampa office. I'm going to be talking today about furloughs, layoffs, and compensation adjustments, which are, essentially the main tools short of government intervention for weathering extreme and unforeseen economic turmoil like we are experiencing at present. And I don't take these topics lightly, and I know that for many, if not all of you, they are really the tools of absolute last resort. And yet, here we are, not even 6 weeks into really the teeth of this pandemic situation. And I know, a great many businesses have had to resort to those. So we're going to walk through some of those concepts here briefly today. Every business, of course, is somewhat unique. I'm a Florida lawyer, not admitted in other states, and I know some of you have business operations in other states or maybe talking to us from other states. So what I'm going to say here really is akin to guidance through a Florida and federal law lens, but there are state-specific laws in other jurisdictions that relate to some of these issues. So, certainly want to work with counsel as you go to implement any of these tactics that we're going to be talking about. And I want to start with some definitions just to make sure that we're all on the same page. In particular, I get a lot of questions about the distinction or difference between a furlough and a layoff. Neither of these terms really have specific defined meanings under the law, but they both have sort of generally understood meanings. So I want to highlight those because they are different. The more cut and dry of the two is a layoff. And a layoff is really just a formal ending of the employment relationship. In that way, it's really the same thing as a termination or a firing or a separation, all different words that effectively describe the same thing. The term layoff, though, is generally used because of its kind of has a different connotation insofar as it's a separation that's not the result of anything the employee did wrong. Rather, it's the result of some extrinsic event like a recession or a pandemic. And consequently, because that's the reason we have layoffs generally, oftentimes it's the case that an employer is laying off more than one person, right? We have multiple layoffs to address business needs, in which case you may have a reduction in force or a RIF, which just refers to multiple employees. And Jan is going to talk in his presentation about the WARN Act about some of the implications of larger group layoffs. The point I want to emphasize is that a layoff is an official termination or ending of the employment relationship. And as a result, the benefits that an employee gets through the employer will terminate per the terms of whatever benefit plans are applicable. A layoff is going to be a triggering event for a COBRA notice if the person is on health benefit plans. And yeah, a person who's laid off generally will be eligible for unemployment. And Mark Connolly is going to talk more about that in his presentation a little later on. If you're laying off employees and planning to offer any severance payment in any amount, we'd strongly encourage you to document that with a written separation agreement and to obtain a general release from the employee in exchange for the severance payment. So that's kind of the high-level overview of layoffs. What then is a furlough? Well, furlough is a slightly fuzzier concept, but generally it refers to a temporary period of time where an employee does no work or does less work than they would otherwise do, and they receive either no pay or a reduction in pay as a result. But, and this is the key and the distinction between a furlough and a layoff, in a furlough, they technically remain employed and would have an expectation of returning to work even during a period when they're not doing any work at the conclusion of the event that prompted the furlough. And we've sort of heard about furloughs most commonly in connection with federal government employees when from time to time Congress fails to pass a budget, and then federal government employees have to go on furlough and they don't work and they don't get paid for a bit. And private sector furloughs are much the same. It's a period where the individual remains technically employed but is doing little or no work and either receiving no pay or a reduction in pay. Furloughs can come in all shapes and sizes. There are furloughs for a fixed period of time or for an indefinite period of time. And also we have sort of rolling or rotating furloughs, a week on, a week off, anything a business might need to sort of adjust and get through a period of, economic stress. So what are some of the advantages for an employer of a furlough over laying off employees? Well, there are a few. First of all, it's a little easier to message that to your employees, right? We're not saying we're letting you go. We're just taking a necessary step to allow us to ride this thing out, and we fully expect you'll be back with us, working full time again when it's over. Administratively, it's also a little easier to handle a furlough if you're going to need those workers on the back end, because rather than laying people off and then having to re-onboard or onboard a different set of workers, if you furloughed them, they remain employed, and thus you don't have background checks, you're not doing I-9s again, you don't have benefits enrollment and all the other administrative stuff that goes with onboarding new employees. Some upsides for employees, right? A furloughed employee may be eligible to remain on company benefits during a portion or all of their furlough time, but that's going to be specific to the benefit plan that you have. And so you'll want to check with your benefits, because oftentimes employees have to work a minimum amount on a weekly basis in order to be benefits eligible. I know some benefit plans are changing those terms to be more accommodative during this difficult time. So check with your benefit plans about whether employees can remain on benefits. Another advantage of furloughs is it may offer a little cost savings over a layoff if you were going to offer severance, right? If you're going to lay people off but pay some severance, but furloughing them is just really hitting the pause button and could present a less expensive option rather than having to pay some severance. The final thing I want to mention about furloughed employees is if they're not getting paid, they may well be eligible for unemployment benefits. That's a state-specific consideration, but there are unemployment benefit eligibility generally for people who have a reduction or elimination of their wages, even temporarily, and Mark, again, is going to speak more about that. A couple of things to keep in mind if you're furloughing employees. If they're not getting paid, we can't have them do any work, and so we want to be mindful of the fact that we want to eliminate remote access and prevent furloughed workers who aren't getting paid from doing work. Otherwise, we trigger a payment obligation to them. And there's a particular consideration in connection with exempt employees, which I'll get to in just a minute. The other thing to keep in mind when you furlough folks is what does your PTO or vacation policy say about what employees, how they may or may not be able to use their PTO, and we just need to make sure that we're not furloughing people and planning to not pay them, and then we have some entitlement to the use of PTO time that may be counterproductive. So just be mindful of PTO, and many employers want their employees to be able to use PTO up, and that's fine, but just something to point out and keep in mind. The next thing I want to touch on is general considerations when we're doing reductions in compensation. And this is anything from, a furlough, like I just mentioned, where you're taking the comp all the way down to zero, to a more modest reduction, say a 10% or a 20 or 30% reduction. Maybe there's a corresponding reduction in the amount of work that the person's expected to do, but maybe there's not. There's any number of kind of permutations on comp reductions that employers implement in times like this. So for non-exempt employees, it's pretty straightforward, right? When they're working, we're focused on making sure that they make at least minimum wage and receive overtime pay if they work more than 40 hours in a week. If they're not working, they don't need to be paid, and we just want to be careful. Let's not change anyone's pay retroactively, right? For hours they've already worked, we don't want to reduce the rate that they're getting paid if they already had an agreed rate. Exempt employees, a little bit more complicated analysis. They do generally have to be paid their full weekly salary for any week that they do work. And so if they don't work, at all during the work week, then we're okay paying them zero. But if they do any work, then a salary exempt employee needs to make their full salary for that week. And consequently, if we're trying to furlough and not pay anything, we need to coincide the start of the furlough week with the beginning of the work week so that we aren't triggering a payment obligation. We also want to be extra careful that they're not, exempt employees aren't doing any work on furlough. If we're talking about comp reductions, so not taking them all the way to zero, but just a percentage reduction, say, our exempt employees, we want to be mindful that if they are going to remain exempt, they need to still be paid above the minimum salary level, which is now $35,568 per year. So you can reduce a salary exempt employee and retain their exemption, but you got to keep them above that minimum salary number. The reduction also needs to be implemented prospectively. So they need to get advance notice of it in advance of it taking effect. And even a couple of days heads up is adequate in that regard, but we can't, again, do anything retroactively. And it needs to be done on a legitimate and bona fide basis, meaning we just can't ping pong a person's salary based on sort of the cash flow this week or next week. If we're going to retain the exempt status, it's okay to bring them down. We're going to bring them down to a new level, keep them there consistently, and then when circumstances go back to normal, you can raise them back up. That's generally been viewed as okay. One other thing to touch on, if we're reducing compensation or making any changes really, and we're doing different things for different groups of employees within the organization, let's just be mindful of potential discrimination claims and document. It is okay to treat different groups within the organization differently, 15% reduction here or 30% reduction there, but let's make sure we've documented the legitimate business reason for the different treatments and, provide ourselves a good solid defense in the event of any claims that may be brought down the line. The last thing I want to mention briefly is employment agreements, right? Because all of the things that I just talked about are on the table and fair game for businesses to make adjustments as they need to in times like this. But you do need to be cognizant of those employees who have employment agreements. Those are, simply stated, contracts. And they dictate the terms of the employee-employer relationship. They typically address, of course, compensation, work time, the services to be provided, and how the employment relationship may be terminated. And even in an economic crisis, the employer does not have the unilateral ability to make changes to the terms and conditions of employment for employees who have employment agreements. Rather, any changes you want to make need to be done within the parameters of an employment agreement. And if the employment agreement doesn't allow you to do what you want to do, then you need to negotiate an amendment of the agreement with your employee. And the ability to do that's going to depend entirely on the terms and conditions of any employment agreement. The good news is, in a difficult economic time, if we discover we've made any sort of goofs or oversights in implementing any of these things, we have the opportunity to address those, clean them up, and fix them. And that's my very quick high-level discussion of furloughs, comp reductions, and layoff issues. And with that, I'm going to hand it off to Jan.
Thanks, Brad. So my topic is the WARN Act. This is guidance that I hope none of you ever need. Unfortunately, we've been working with clients through this. So the WARN Act is the Worker Adjustment and Retraining Notification Act. It is a federal law that requires employers to provide at least 60 days advanced notice to employees and governmental agencies of a plant closing or mass layoff, and we'll talk about what those terms mean. If employers do not provide the required WARN Act notice, they face class action liability for the back pay and benefits during the notice period, plus attorney's fees, plus potential civil penalties of $500 a day or up to $30,000. You may have seen in the news that WARN Act lawsuits have already started. I guess Hooters did a reduction in force recently, and they were just sued here in federal court in Tampa for allegedly violating the WARN Act. The first topic is, who is a covered employer? Who needs to worry about this act? And the short, simple answer is, under the federal WARN Act, a covered employer is any employer that has 100 or more employees. That does not include part-time employees. Part-time is defined under the WARN Act as an employee who works less on average than 20 hours per week. And I will caution you that there is the possibility that you have to count part-time employees if you have a substantial number of them, usually in excess of 200. If you have less than 100 employees, this is typically the part of the seminars where I tell you you can put your head down on the desk and I'll wake you for the next section. However, I have to warn multi-state employers, as always, your job is more difficult. There are around 20 states that have a mini WARN Act that have similar requirements and may have a smaller employee count for you to be covered. So you have to be cognizant of that. When do we have to give notice? All of that depends upon the definition of the term employment loss, plant closing, and mass layoff. So let's start with employment loss. An employment loss is any termination but one for cause, retirement, or voluntary resignation. So you do a reduction in force, that is an employment loss, okay? WARN also provides that temporary layoffs that exceed 6 months are an employment loss. To say that a different way, a temporary layoff lasting less than 6 months is not an employment loss and doesn't lead to a WARN Act notice requirement. Employment loss also includes a reduction in hours. An employee who has their hours reduced by more than 50% in every month in a 6-month period has suffered an employment loss. So layoffs, termination, furloughs, all the things that are going on right now may be WARN Act events. So now that we know what an employment loss is, that will help us determine, did we have a plant closing or a mass layoff, either of which will trigger the requirement for a WARN Act notice. A mass layoff is a employment loss for one of two things. One, either between 50 and 499 employees, of which those employees constitute at least 33% of the employees at that site, or an employment loss of 500 or more employees at that site. When you're doing a WARN Act analysis, it's important to remember, both for mass layoff and a plant closing, that it is site specific. So it's not, did I lose 50 employees company-wide? It's, did I have an employment loss of 50 employees at this site? All right, so that's a mass layoff. What is a plant closing? A plant closing is the shutdown of a site of employment or an operational unit that leads to the employment loss for at least 50 employees. The important part, and this is a little bit of a misnomer in plant closing, it confuses clients because it doesn't mean that the whole employment site has to shut down. It can be just an operational unit. So if we have a factory and we end the third shift is an operational unit. If it shuts down and more than 50 employees suffer an employment loss, even though the factory keeps running, we may have a WARN Act event. In counting up how many employment losses we have, it's important to remember that they can be aggregated. The general rule under the WARN Act is you're supposed to look forward and backward 90 days to see if you meet the number of employment losses. There's an exception to that where if you actually have a plant closing or mass layoff where you have a day where you meet the numbers, then you only have to at that point look forward 30 and back 30. But generally, it should be a 90-day look back. All right, let's talk about WARN Act exceptions, because this is an area we're finding a lot of client confusion. The WARN Act has a number of exceptions, 2 of which are potentially applicable to coronavirus. The first is the natural disaster, and the second is the unforeseen business circumstance. We're a little concerned about the natural disaster exception, that it may not apply. The language basically provides that the natural disaster must directly cause the employment loss. First, the examples of a natural disaster do not reference a pandemic, generally fire, flood, those type of things. So there's first the concern that plaintiffs' attorneys will probably argue that coronavirus is not a natural disaster. Even if we can get past that, we're concerned that the coronavirus is not the direct cause of the employment loss. The examples that are provided generally are a flood of the factory. The flood causes the inability to work. The issue here is going to be, is it coronavirus that is leading to these employment losses, or is it a loss of customers or revenue or a government shutdown, and is that directly caused by coronavirus? We think the unforeseen business circumstance will be the better exception. We still plan to use both, but the unforeseen business circumstance is that there was an unexpected event that we couldn't have foreseen at the time we were supposed to give the notice, so 60 days ago. So we're at April 20, so on February 20th, was it foreseen that we would have to lay off or shut down the third shift now? If it was not, then this may be an exception we can use. The longer coronavirus goes on, the more difficult it will be to make the argument that we couldn't foresee this. Additionally, when you're using the unforeseen business circumstance exception and it's challenged, realize that all of your internal discussions and emails regarding this would be discoverable. And so often the litigation issue is, what did the employer know and when? So to the extent that you can involve your in-house counsel or outside counsel in those discussions and try to keep some of those discussions attorney-client privilege, that may help you in the future. A very important point about using these exceptions. These exceptions do not excuse you from providing a WARN Act notice. What they allow you to do is provide a shortened, less than 60-day WARN Act notice. And it can be as short as no notice or 1 day's notice. But to say this a different way, if you don't give a WARN Act notice, you can't rely on these exceptions as a defense, okay? And even more importantly, when you give the WARN Act notice and rely on these exceptions, you have to identify them and give a short factual summary as to the reason or your reliance upon them. So again, if you're going to rely on one of these exceptions, you still have to provide the WARN Act notice, although it may be immediate or with 1 day. Some practical guidance in working through WARN Act notice. Look, many employers right now believe that your layoffs are temporary. We plan to bring all these people back in less than 6 months. We should be saying that in our termination letters or in our notices to them, right? Because that's going to delay your potential WARN Act lawsuit. I think that may be one of the issues, and again, I haven't looked into it deeply, that Hooters may be facing is that they terminated everyone as opposed to telling them that this was a temporary layoff that they expect last less than 6 months. A termination is an immediate employment loss. A temporary layoff doesn't become an employment loss until it's lasted 6 months. So we should be providing notice that the layoff is, we expect to last less than 6 months. What happens if we get it wrong? What happens if 6 months from now we can't bring people back? Well, at that point, the failure to give notice when we did the temporary layoff may lead to WARN Act liability. However, there is the possibility that during that 6 month period, we can issue a WARN Act notice and explain what the intervening event was that's leading the temporary layoff now to become a termination. And again, if we give 60 days notice before the changing it from a temporary layoff to a permanent termination, we may be able to use that as a defense. Alternatively, what some clients are doing is they are providing notices that say that this is a temporary layoff. We expect it to last less than 6 months, but just in case, if we're not, here's your WARN Act notice, and we're relying upon the unforeseen business circumstance for these factual reasons. This way, if we can bring people back in less than 6 months, great, there's been no employment loss. If we can't, then we gave the WARN Act notice at the time, and we're just litigating, did we have an unforeseen business circumstance? Two final points. WARN Act claims can be released with a general release. If you have WARN Act concerns, this may be a reason to give a little bit of severance in exchange for a separation agreement. Right now, we have clients that are just giving separation agreements for 1 week's pay or the equivalent of 1 week's unemployment benefits, about $875. And employers are telling clients, look, we know the unemployment system is clogged and you can't get through, so we're going to offer you a bridge until you can do that. If they accept that agreement and sign the general release, that general release would be a defense to any potential WARN Act claim. And then the last bit that this isn't WARN Act, but remember, if we're doing separation agreements and we're trying to get a release of an age discrimination claim, we have to worry about the Older Worker Benefit Protection Act. This is the law that means we normally have to give them 21 days to think about the separation agreement and 7 days to revoke. However, if we have a termination plan, which is defined as more than one employee who's being offered the severance and release, we have to now give them 45 days to think about the release, and we have to give them the same 7 days to revoke, but we have to give them some additional information about the termination plan, what group or class of employee was considered for it, and then all the members of that class or group who were selected and who were not selected, and identify those employees by their title and age. If we don't give that additional information, the age discrimination release will not be valid. Again, I hope none of you need any of this information, but if you do or just want to talk through any of this, please give me a call. With that said, thank you, and I'll let John Burgess go with employee benefits.
Okay, thanks, Jan. My name's John Burgess. I'm a partner here in Tampa. I primarily work in employee benefits and tax, so 401k plans, welfare plans, executive compensation, ESOPs. I do all that sort of stuff. There are really two main issues that people have been coming to us to talk about in the past few weeks since all of this has started. Number one, health coverage, and number two, there are some new distribution options and just some general administrative stuff you want to keep in mind for your 401k and your retirement plan. So let's talk about health coverage first. What most employers who are going through furloughs are saying is, yeah, we need to, put these people's employment sort of on hold, but we want them to keep their health coverage. How can we do that? You can do that, and there are a couple of different ways that it may happen. If instead of a furlough, let's take a step back here. If they decide to lay them off, which is as Jan mentioned, a permanent termination, that is a COBRA event, so they will be able to keep their coverage. They will be able to go on COBRA, and you can, as an employer, subsidize that to an extent. So that may be another way to get a release form, is to have some of their COBRA coverage subsidized by the employer, like it is with active coverage. But let's say it's a furlough, and the intent is to bring the employee back at some point in time. They may remain eligible for your plan under the terms of the plan. And again, this is going to depend on what the terms of the plan say. You need to look at those eligibility requirements to determine how long would these people stay eligible on our plan based on their reduction in hours. In some plans, it'll be an immediate event where they would lose eligibility. And in some plans, there may be some language in there that allows you to keep them on for a while. For example, worked with a client a few weeks ago where their plan specifically had language to say if somebody is on a leave of absence of no more than 90 days, they will be able those employees will still continue on active coverage. So in that case, they were implementing a furlough. It was planned to be about 30 days or so. So it's pretty easy that the plan clearly addressed it. That's not always going to be the case. Now, if you have a situation where you look at your plan and you determine that due to the furlough, they would lose eligibility, you might be able to, in working with your insurance carrier, amend the plan so that they will continue to have coverage through the temporary layoff period, where they're no longer, even though they're technically an employee, they're no longer providing services or the minimum number of hours that are typically required for them to maintain eligibility. Again, you do want to work through this with your insurance carrier. Just from the feedback that I've received, most carriers have been pretty flexible with working with people because they know that this is a temporary thing. They know that employees are going to come back. Assuming that doesn't happen, though, a reduction in hours like that under a type of furlough would be a COBRA event as well. So again, they would go on to COBRA, they would be able to continue their coverage without a gap, and so eventually when they would come back, they would regain their status as an active employee, they would come back. Now, all else being equal, it's usually easier, again, this is the same thing that applies if you have a layoff where you're terminating people and bringing them back. It's easier just from sort of a paperwork standpoint to have them continue on active coverage. If they go on to COBRA, you have to do the COBRA notice paperwork, they have to make elections, and then when they come back, they also have to make an election since their status changed and they're back as an active employee. So all else being equal, if you can get them to continue on active coverage without going through the COBRA part, that's preferable, but you do have COBRA to fall back on if you want to do that. The other question people tend to ask is, can employees continue to just pay their normal employee share during a layoff period or a temporary absence? The answer is yes, but then they have the employee portion. How do you recoup that? What do you have to do? What most employers will tend to do is to just continue to subsidize the full cost of the coverage. The employer will pay that while the employee is not working and not getting paychecks. And then what they'll do is that once the employees come back, they'll recoup that on the back end so that they will essentially make up those contributions from before. So at the end of the year, everything will be trued up and the employee will have paid the normal employee cost. The other thing you can do if you want to, and if employees are willing to do this, is have the employee send in checks separately to the employer so that they can cover their cost of the coverage. Again, both of those methods work. Probably the first method that I talked about is a little bit easier because you just take that out tax-free, the employee's not having to write any checks, but both of those options are available to you. So those are the nuts and bolts of healthcare coverage. Again, if you have any questions about this, we can look at these plan documents and figure out pretty quickly what's the eligibility like under your specific circumstance. Let's talk a little bit about 401k plans too. The CARES Act provided some new what are called coronavirus distributions that are available to 401k plans. My guess is that most of the third-party administrators, so the people like the Vanguards of the world, the Fidelities, those who are actually running your plans, have probably already reached out to you and may have even reached out to your employees about these type of distribution options. But what they do is they allow employees who are impacted by coronavirus through, actually being sick, having to miss time, or maybe having hours reduced or pay reduced because of the virus, to take distributions from their 401k plan or their IRA. The maximum distribution is $100,000. It comes out without any taxes withheld, which normally when you take a distribution out, you have to pay a 20% if you're not rolling it over. 20% would be withheld. And it's also exempt from the 10% excise tax that normally applies to early withdrawals from 401ks or IRAs to anybody who's under age 59 and a half. That tax is permanently waived. Now, the good thing about the coronavirus distributions is that you take this money out, but you do have an opportunity for the 3 years after you take the distribution to repay that amount back into the plan and not be taxed on it. So if you do have tax, it will be there and you don't pay it back, but it will be spaced out over 3 years, but you do have that opportunity to repay the amount and you don't have to pay any taxes on it. There's also a little bit more in terms of loans that are going to be available from 401k plans. In sort of the traditional world, the maximum loan that you can take is $50,000. For anybody who's impacted by the virus, that has been increased to $100,000 temporarily through the end of the year. And then you can also borrow up to 100% of your account balance versus the normal 50,000. So a few other options if you want to set it up as a loan, and that would run as a normal loan through your plan. So it would be repaid through payroll deductions and be repaid over a 5-year term. So those are a couple of options that Congress has given us to help you maybe get some liquidity out of your 401k plan. The other thing I want to mention too is that you do need to keep administering your 401k plan and paying attention to it. It's probably not the most prevalent thing on your mind right now with everything else that's going on, especially even just in the benefits world with health insurance. But the first quarter of 2020 just ended a few weeks ago. You should be getting reports from your record keeper about how your investments performed. With most of them, obviously, there was a big dip in March in the market, so your investments were probably down for the entire quarter. I know they've rebounded a little bit in the first few weeks of April here, but you do need to keep paying attention to things. If you normally have an investment committee or a fiduciary committee meeting after the first quarter, you need to keep having those. There's no reason why you can't do those remotely. So you can go over your investments, talk with your investment advisor if you have one, and just keep paying attention to the plan. You know, I did one of these for a client which just implemented a new 401k plan just last year. Just ran through that meeting, went as normal. You know, obviously nobody was in the same room together, but we went through all the things that people needed to know. We talked about these new distribution options. We talked about administration. So bottom line here is don't sleep on your 401k administration through this crisis. Even though, like I said, there are a lot of other things going on, you do want to make sure to keep paying attention to that. With that, I'm going to turn it over to Mark, who's going to talk more about the unemployment benefits.
Thank you, John. Good afternoon, everyone. My name is Mark Connolly. I'm a litigator in the Tampa office of Shumaker, Loop & Kendrick. I assist Jan and our clients on a variety of employment law matters and employment law litigation. I'll be talking to you a little bit today about unemployment and primarily about benefits that are available to your employees under the newly adopted CARES Act. Unfortunately, the state of Florida has been lagging the other states in processing unemployment claims. There have been over 1.5 million unemployment claims submitted in Florida since mid-March. And according to a new state of Florida DEO website tracking the state's performance in processing unemployment applications and paying out benefits, of the information on that website today, only approximately 25% of the claims submitted have in fact been processed. The governor keeps talking about adding more personnel and adding new electronic resources to assist in the processing of those claims, and hopefully that will get cleared up over the next few days and certainly hopefully over the next few weeks. The CARES Act provides benefits in a variety of ways to businesses, and you're all familiar with the PPP loans, and I'm hopeful that a number of your businesses were able to obtain them in the first wave of those loan applications. The CARES Act also expands the scope of individuals eligible for unemployment insurance and for individuals who are not normally eligible for unemployment insurance, and also increases the amount that individuals receive. The Act has three key programs that I'll be discussing with you, and we'll start with the Pandemic Unemployment Compensation, which is Section 2104 of the new CARES Act. Starting with who is eligible. Individuals who, as determined by the applicable state law, meet the state's criteria to receive unemployment benefits. What's the benefit provided? The law provides an increase of a flat payment of $600 per week to the amount regularly available for unemployment under state law. Then you ask, are there additional criteria that must be met to receive the PUC benefits? And there are none. As long as you qualify under state law, you're eligible for those benefits. And the time period for the increased compensation, it applies to the period where the state agrees to participate in the program and continues through July 31, 2020. So that's a period of approximately 4 months. That's a very nice needed benefit to employees that would otherwise be eligible for very limited benefits under Florida law. The next program is the Pandemic Unemployment Assistance, which is 2102 of the CARES Act. Starting with who's eligible. Individuals who are not usually eligible for unemployment benefits, including those who are furloughed or out of work as a direct result of COVID-19, self-employed and independent contractors, and those who have exhausted existing state and federal unemployment benefit provisions. And there's significance to note here, individuals who have the ability to telework with pay, and those who are receiving paid sick leave or other paid benefits, even if they otherwise satisfy the criteria of the Act to receive assistance under this law, are expressly excluded from coverage. So under this Pandemic Unemployment Assistance, what's the benefit provided? The PUA benefits equal the minimum weekly benefit amount described in the Stafford Act Disaster Unemployment Assistance Act program, which really the amount determined under that program is based upon state law. And that Stafford Act is the model for the PUA program. But critically, in addition to those amounts, they're also entitled to $600 per week of federally funded supplement, similar to that provided to recipients under the PUC. So in Florida, since unemployment benefits are capped at $275 to begin with, the $600 benefit is a nice supplement to whatever would be available under state law. And then there are additional criteria that must be met for employees to receive the PUA benefits. The applicants for the PUA must provide self-certification that they are partially or fully unemployed or unable and unavailable to work because of one of the listed circumstances set forth in the Act. And I won't go through all of them, but many of them relate to whether or not the individual himself or herself has been diagnosed with COVID-19 or experienced symptoms of COVID-19 and seeking a medical diagnosis, or is providing care for someone in their family member that has been diagnosed with COVID-19. And there's a number of different criteria that I'd suggest that you'd have your employees take a look at that provide the basis for them to have eligibility under that section of the CARES Act. Finally, the third program is the Pandemic Emergency Unemployment Compensation, or PEUC, which is section 2107 of the CARES Act. Starting with who is eligible, the unemployment insurance recipients who exhaust all of their regular state unemployment benefits, which depending upon state can range from as few as 12 weeks to a maximum of 26 weeks, are eligible. The benefit that's provided under this portion of the CARES Act is an additional 13 weeks of state unemployment insurance benefits. And for the criteria, individuals must have exhausted their regular state unemployment insurance benefits and be actively engaged in searching for work. The benefits available under the PEUC are available through December 31, 2020, unless otherwise extended. Other key provisions of the CARES Act, there is a short-time compensation program. The CARES Act provides funding to support short-time compensation programs where employers reduce employee hours instead of laying them off, and employees with reduced hours receive a prorated unemployment benefit. This provision does not provide new or additional benefits. Rather, it provides for federal funding for these programs through the end of 2020. And for states with existing short-time compensation programs, the federal government will fully fund the state's program. On this issue, turning to the state of Florida with regard to short-time compensation programs, there is a program that's set up under Florida law. It is a voluntary program. It's designed to help employers maintain their staff. It has certain requirements for the employer, starting with, as an employer, you must complete a short-time compensation plan application, and that application has to be approved by the Florida Department of Economic Opportunity. As a result of that process and the amount of backup there is right now with the Florida DEO, this is a program that we think on a practical level would be difficult to move forward with, and it is my understanding that at this point in time we don't have any clients that are going forward with this process. To the extent that you have an interest in moving forward with it, we can talk about that offline. As far as requirements, at least 10% of your employees and your total staff or in a particular department must work the reduced hours. So that's a minimum of 2 or 10%. And then as an employer, you must certify that you will reduce the employee's normal number of weekly work hours by at least 10%, but not by more than 40%. This is available only for full-time employees, and those individuals must meet all the normal requirements to establish a Florida reemployment claim. One of the bullet points that you have in front of you is the FFCRA, which Chris has already covered. What is significant to note here is that if your company is providing paid leave to employees, your employee is not entitled to receive unemployment benefits. Turning then to Florida reemployment assistance, each state has its own state-specific unemployment benefit protocols, and those vary greatly from state to state. In Florida, unemployment benefits are referred to as reemployment assistance, which are governed by Chapter 443 of the Florida statutes. Under Florida law, whether a person qualifies for reemployment assistance and how much he or she qualifies to receive is determined by analyzing whether the employee worked and earned enough over the past 18 months. Independent contractors before the CARES Act were not eligible for Florida reemployment assistance, and this is something that's been modified in Florida to comport with the CARES Act in order to get benefits under the CARES Act. There are two types of reemployment assistance in Florida. One is for total employment. The other is for reemployment assistance for partial employment. To qualify, employees must have been temporarily laid off through no fault of their own, must be able to work, and must stay in contact with the employer and be available to work when called back by the employer. There's quite a few requirements. I'll go through just a few that may be of interest to you. The wages used to determine employees' benefit amounts are the first 4 of the last 5 calendar quarters. And once wages are established, an employee becomes eligible for reemployment assistance if the employee earned $3,400 minimum gross earnings, had 2 quarters of covered wages, and the total base period gross wages are more than 1.5 times the highest wage quarter. In Florida, if the employee qualifies for reemployment assistance, he or she is currently entitled to a maximum of $275 per week in reemployment assistance, up to the maximum benefit amount of $3,300. Of course, that's before the CARES Act provisions, which would provide additional benefits on top of that. And those numbers vary greatly from state to state. Florida is at the very low end of the benefits being provided. I'd like to turn then to some of the issues that I've seen raised on a regular basis under the CARES Act, and there's a few questions that the state of Florida has answered, which Rick Scott provided some Q's and A's that I believe would be of relevant for you. When you're discussing with your employees, are they eligible for unemployment insurance? In the state of Florida, at least, the Florida DEO is the entity that they need to be visiting. And if they haven't already gone online, that's the place to find answers. Part-time workers who lost jobs because of the coronavirus, are they eligible? Yes, part-time workers would be eligible for benefits, but the benefit amount and how long benefits are last for them depend on the DEO's guidance. They will also be eligible for the additional $600 per week benefit. If someone cannot work because a child's school or daycare is shut down, are they covered? If an employee relies on a school, daycare, or other facility to care for a child, elderly parent, or another household member so that they can work, and that facility has been shut down because of the coronavirus, and therefore they cannot work, they are eligible. And we have a number of questions that have been asked of us that we'll be discussing at the end of the presentations, and I'll hold off on those for now. So thank you for attending today.
Thanks, Mark. This is Jan Pietrowska again. We're going to move into the pre-submitted Q&A now. We've received a lot of questions. We've done the best we can to keep our presentation short and still get the information out to you. I know this is just scheduled to go through 3:30, but all of us will remain on as long as we can to try to get through as many of these questions as we can. If we don't get to your question, feel free to email rsvp@shumaker.com or me, and we'll find someone who can get you the answer. Some of the questions we got are pretty detailed or fact-oriented, and for those we may give some quick answer, but as with any legal issue, sometimes the details are important. So if we get to your question and you want more information, we're going to try to identify who the speakers are as we go through the questions, and either email the person who's answering your question or just email me and I'll get you connected with the right person. So, and again, I know everyone's time is valuable. To the extent that you can't stick around for all the questions, feel free to log off when you have to. And I, again, just remind everyone, we are looking for feedback on how we can make this better. With that said, we're going to go ahead and get started with the Q&A, and we'll move forward. So here's the first question. We'll put the questions up, and we've already sort of sorted them, so we know who's going to be answering which ones.
So yeah, the first question is the one that I'm going to be handling. It says, must an employee exhaust their employer-provided sick time prior to utilizing the Federal Sick Time Act hours? The answer to that is no. We cannot force an employee to use their federal paid sick leave, or for that matter, employer-provided leave, prior to using the federal paid sick leave. Now, there's one caveat I want to mention here, is that we can't force them to use it right beforehand. But one way that we can sort of force them to use it up is if they're taking expanded FMLA leave. After those first two initial unpaid weeks expire, once they're on the remaining 10 weeks, we can require them to use their federal, their employer-provided sick leave during those 10 weeks concurrently. So again, after those first two initial weeks of expanded FMLA leave expire, we can require them to use their employer-provided leave concurrently with the remaining 10 weeks.
So the next question is, how are partial unemployment benefits calculated in Florida? An employee is partially unemployed in Florida in any week of less than full-time work. If the earned income payable to him or her for that week is less than his or her weekly benefit amount under the statute. So Florida's current weekly benefit amount is capped at $275 for a maximum of 12 weeks for a total of $3,300. And most employees earning more than $28,600 during the previous year will be subject to the cap. So in most instances, the practical definition of partial unemployment would be any week of less than full-time work where the employee earns less than $275. However, note that's a general rule of thumb based on the manner of calculating the weekly benefit amount under the statute. Calculations may be different for employees who have not continuously worked and earned wages since January of 2019. They may even be ineligible for reemployment assistance, or for those who have gaps in their employment where they did not earn wages. There's more information on this. To the extent that you'd like to follow up on this, I'd be happy to discuss it with you. Yes, so on this issue, you are correct. If an applicant must be eligible to receive state benefits to receive the additional $600 in federal pandemic unemployment compensation, the eligibility for state benefits is calculated without respect to the additional federal benefit, and the $600 is stacked on to the applicant's benefits, if any. The $600 weekly benefit will not be available after July 31, 2020, unless Congress extends the program. And the Section 2107 program you're referring to is the Pandemic Emergency Unemployment Compensation, similarly titled but different from the Federal Pandemic Unemployment Compensation. And this program provides for an additional 13 weeks of unemployment benefits for individuals who have exhausted benefits they're otherwise entitled to under state law. The individual must be eligible for state benefits, but have exhausted the number of weeks that they can receive the benefits. The additional 13 weeks will be paid at the same weekly rate the individual is otherwise eligible to receive under applicable law, which includes the additional $600 benefit until that program expires on July 31. And this program, the 2107 program, expires on December 31.
I would like to know what type of documentation should we ask for from our employees who would like to take leave under the Families First Coronavirus Leave Act. So we know that there are two types of documentation that we are required to obtain. The first is that request form that has the required information that I went over before, the name of the person, the dates of leave that they're requesting, the reason for the leave, and then depending on the reason for the leave, the additional information required. The second piece of documentation that we're required to get is an employee statement certifying certain things, specifically that they're unable to work or telework based on the reason why they need leave, and also some other information required to get tax credits. So those are two forms that I would say that even though the regulations don't say that you're required to use a particular form, they do say that you need to get those two types of documentation. And I would just recommend that you use a standard form every time to make sure that you're implementing it uniformly. We need to be careful about requesting other documentation. What do I mean by that? There's a temptation that if an employee is saying that they have a medical issue or that a family member has a medical issue, that maybe we should ask them for a doctor's note. The regulations don't say anything about allowing you to ask for a doctor's note, okay? And in fact, the regulations make clear that unless the information is otherwise required under the regulations, you can't ask for anything else. So I think it's very risky to ask for a doctor's note for leave requested under the coronavirus leave laws. Same thing with proof of a school closing. This just goes to show you how fluid this situation is. A couple weeks ago, I read the questions and answers provided by the Department of Labor. And at one point, the DOL was saying that you could request some proof from the employee that their kid's school was closed, like a notice of closure on a website or in the newspaper. I checked this morning, I cannot find that anywhere anymore. So I believe that the DOL has taken that away, which leads me to believe that the DOL is serious when they say that if it's not one of those required pieces of information that is included in the regulations, we can't ask for it. There's one exception to that I want to note, and that is that if the employee has a serious health condition of their own, or if their family member has a serious health condition, and if you're otherwise covered by the FMLA, well then remember the regular FMLA rules would apply, and therefore the regular FMLA certification rules would apply. So if you have noticed that your employee has coronavirus, for example, or if their family member has coronavirus, that could give you and should give you reason to provide the normal FMLA notice of eligibility and to get a medical certification from their doctor. So that's one way of getting around the otherwise limited amount of information that we're allowed to get under the Families First Leave Act.
This is Brad. I see the next question. Understanding the difference between layoff, furlough, and fire. We talked about that on my presentation, but part 2 of that question is with the PPP rules, understand you must have the same number of FTEs, not necessarily the same exact people. Is that accurate? And that is correct, right? So there may have been a change in who's in the roster or the lineup, but the number needs to be the same in order or with respect to those triggers for the forgiveness eligibility under the PPP. Next question, can an exempt employee be partially furloughed? Yes, they can. The question is whether they're going to retain their exempt status. And as I mentioned, obviously to be exempt, you need to meet a couple of criteria, including being paid on a salary basis and at the minimum salary level. So depending on what you mean by partially furloughed, if they're still paid at or above the minimum salary level and it was the furlough or the reduction was prospectively implemented, and we don't have a lot of ping-ponging of the compensation amount, then yes, even a partially furloughed employee who's paid above the minimum salary level on a salary basis could conceivably retain their exemption. If they're not going to continue to be paid above that minimum salary amount, though, you could still partially furlough them. They're just going to lose their exempt status for the time being. But in an era when, or in a time period when there's not a lot of work to be done, the risk that they're going to incur any overtime may be relatively small. And the Department of Labor has said that you can take an exempt person, make them non-exempt for a period of time, and then they can regain their exempt status after an economic event that has rendered them non-exempt, such as putting them on a partial furlough. So that's how you work through those.
Hello, this is Jack Santinello. I'll take this next one. So, because we're getting kind of into the PPP stuff. So, the question is, if you get approved for a PPP loan, can you also claim the paid leave credit, or is that considered double dipping? It's interesting in that there are some things that you would think that are double dipping and others that are not. And so, for example, the payroll tax credits, when you talk about sick and family leave, you can ask for and obtain a PPP loan, but if you do, you can't include those credits, you can't include that amount that you got credit for. So in other words, when you're getting a credit for having incurred the payroll, but then you're getting reimbursed for it. So it kind of makes sense that is, it's not that you apply for it and get the credit, it's that the use of the funds is where the double dip can occur potentially, similar to using EIDL funds for the same purposes as you use your PPP funds. With respect to employee retention tax credit, though, that is, you can't mix. That's oil and vinegar, essentially oil and water, essentially that. You can't take an employee retention tax credit under the FFCRA for which an employer also receives the payroll tax credit. So kind of makes sense. Again, if you think about it, what the purpose of the money that you might get or will get under these loan programs and these credit programs, that you're not double dipping with respect to the use of it. Okay. So employer receives loan and claims the paid leave credits are penalized prior to applying for the PPP loan forgiveness, or do you not deduct it from the pay? Okay, so similar, it's kind of related. Also, if you were to have Social Security tax exempted and receive the loan forgiveness, then you would apply, would you pay the Social Security tax that was exempted? So a lot of stuff to unpack there. So the reality is that because of the way this process went down, there's, you had to apply, and you also had to potentially, or would have potentially, stopped paying the employer's portion of Social Security. So you're not going to get penalized for having done that. There is a day of reckoning that will occur down the road. And so when you start asking for forgiveness for having used PPP funds for an appropriate purpose and during the appropriate period of time, which is 8 weeks, and we'll talk about that as well, then it all balances itself out. So again, you can't double dip. And then the Social Security taxes or that you haven't paid or that you have deferred, then that gets paid out at the end of it's a 2-year process. So by the half of it by the end of 2021, the other half by the end of 2022. Once you receive your PPP loan, you cannot continue to defer your employer side Social Security tax. You must then start paying it as per normal. So it shuts that spigot off or shuts that deferral off for you.
Please, and this is Chris Cavalieri again, please address small businesses and their responsibilities. We are not required to follow regular FMLA rules, and most seminars address larger companies' regulations. Great question, and in fact, the next question, I believe, is very similar. So I'm going to cover both. And the next question was, our main question right now is, what exceptions are we eligible for as an employer with less than 50 employees? So again, we're talking about small businesses. We only have 14 employees. What would our obligations be with regard to the paid leave under the COVID-19? If we qualify for exceptions, what would we need to do to get them? So let's unpack the small business question. First of all, as I went over before, if you have under 500 employees, you're covered under the Families First law, okay? When it comes to paid sick leave, if you have under 500 employees, you're required to provide paid sick leave as long as one of those 6 reasons is met. When it comes to expanded FMLA, if you have under 500 employees, and as long as the employee who's requesting leave has worked for you for at least 30 days, you're required to provide expanded FMLA leave as long as they have got qualifying child care reason. There's an exception for when you employ a healthcare provider or an emergency responder. You can deny those particular employees leave under either one of those 2 types of paid leave. The small business exemption I went over before, and that's the exemption that applies when you have under 50 employees and it's a child care reason and an authorized officer makes one of those 3 determinations and documents it. That's the small business exemption that we went over before. Again, remember, it's not a blanket exemption that allows you to get around providing leave for all employees. Think of it as an employee case-by-case ability to deny leave, right? Let's talk about some other exceptions that apply to small businesses. There are really only 2 more. The first, and they both have to do with your obligation to restore an employee to their same or an equivalent position under expanded FMLA. Okay, so as we probably know, the regular FMLA requires that after someone comes off of FMLA, you need to restore them to the same or an equivalent position. The expanded FMLA leave has the same requirement. There is an exception, though, for companies with fewer than 25 employees. There's an exception for those companies when these following conditions exist, for you having to comply with that restoration obligation, okay? What are those conditions? Number 1, the position no longer exists due to economic or operating conditions and due to COVID-related reasons. Number 2, important, you have to make reasonable efforts to restore the employee to the same or an equivalent position. Number 3, you have to make reasonable efforts to contact the employee if an equivalent position becomes available. And number 4, here's the biggie, you have to continue to make reasonable efforts to contact that employee for an entire year after their EFMLA leave expires. As long as you comply with all of those requirements, you can get around the requirement to restore an EFMLA employee into their same or similar position. There's one more exception to this restoration requirement. That is when an employee is a key employee. This is a little unclear because it's unclear to what extent the normal FMLA definition and rules regarding key employees are imported into the EFMLA. But basically, the employee needs to be salaried. They need to be among the top 10% earners within 75 miles of the work site. And then the remaining requirements are unclear as to whether they apply or not. Normally under regular FMLA, you got to show that the business would be crushed from restoring the employee. You have to have provided notice to the employee before they went on leave that they would not be restored into their same position. And you normally have to give the employee a reasonable opportunity to return to work. Again, those last three are unclear. But other than that, there are really no exceptions for small businesses.
So this is Mark Connolly. The next question is, how does the STC benefit the employee versus partial unemployment benefits? In both cases, the employee would receive their weekly benefit amount, which would be capped at $275 in Florida, with reductions based on the actual wages received during the given week. The exact amount payable to the employee under one program versus the other would need to be calculated on a case-by-case basis as determined by the Florida DEO. Note that the Department of Labor has clarified that employees receiving STC benefits are eligible for the additional $600 per week federal benefit. So the amount of state benefits received under STC versus partial unemployment is really dwarfed in any event by the federal component of the benefits available to the employee. And if we go on to the next question, it also relates to the short-time compensation program, and it's sections 2108 and 2109 of the CARES Act provide for reimbursements directly to state governments who administer short-time compensation programs. Florida's program requires the employer to have a plan approved by the Florida Department of Economic Opportunity. As I indicated earlier, we believe this would likely be a significant administrative burden given the current workload of the DEO, which is scrambling to process hundreds of thousands of regular benefit applications. The weekly short-time compensation benefit amount payable to an individual is equal to the product of their weekly benefit amount under Florida's unemployment statute, which again is capped at $275, and the ratio of the numbers of normal weekly hours of work for which the employer would not compensate that individual to the individual's normal weekly hours of work. And again, to qualify under an STC program in Florida, the hours of reduction must be greater than 10%, cannot exceed 40%. And so for a 40-hour employee being reduced by the maximum amount allowable under an STC type of plan, they would be reduced by 16 hours, and their weekly benefit would be calculated as 16 over 40 times 275, which would result in a benefit of $110, assuming that they make enough to hit the weekly benefits cap. And again, to the extent that anybody that's on this call is interested in setting up an STC program, I'd say reach out to one of the people on the call, and we can provide assistance in putting together a plan and seeing what we can do to assist in getting an STC approved, given what we see as being some very tough hurdles right now at Florida DEO. So just more pros and cons. So this is again pros and cons of the STC. Yeah, so the program provides a state benefit to employees working reduced hours on a temporary basis, and the reduced hours must be used as a means to avoid a layoff. Employees receiving benefits must have been full-time at least 32 hours a week prior to the reduction, and must work a predetermined number of hours per week as part of the program that's submitted to the state of Florida. At least 10% of the total staff must be working the reduced hours. And again, as I just mentioned, you've got a reduction of between 10% and 40% on the number of hours. Again, the STC program will be something that we would work with you on in putting together a plan.
So first of all, I want to go off on a little bit of a tangent, and on behalf of the Shumaker crew, apologize for two things that we are not going to be able to answer for you today. First of all, the fact that you are likely, or many of you are working from home and are closer to your pantry and refrigerator doors, we can't help you with that. And secondly, the fact that you are stuck in your house with the people that you are married to or created and need an escape, we can't help you with either that. We're not psychologists either. So having said that, we can share what information that we know. So with respect to additional funds, and Jan may know more about this than I do at this point because I've not been paying attention to live television today, but they blew through that first amount of money pretty quickly. I mean, it was, I think, 300 billion or so for that was gone in about 14 days. And my understanding is
21 billion,
right. And so they're working.
Supposed to be signed by the Congress today.
Right. And I don't know if
it.
it's been signed. I've kind of been glancing up at the line underneath my.
Okay. 4 o'clock.
4 o'clock, perfect. And so it looks like, I think the numbers are maybe 370 billion or so for small businesses, or maybe it's like 310 or so. And then they've split that up. They have money in there for the EIDL program, for the PPP program. They have some for hospital funding. And I think the big issue, or the issue of contention over the past 24 hours, has been the last component, which is test funding for the various tests in order to test for COVID-19. So that's, have you heard anything additional to that, Jan?
That they finally reached the agreement on that and came up with the funding. And I hear it's going to be signed at 4 o'clock and hopefully signed by the president by the end of the day.
And I would also suggest that you look into, and I'm in Charlotte, North Carolina. So for example, the Chamber of Commerce here, there's various nonprofits that are community-based that have put together funds. So I would seek out additional potential monies. Industries have put together their own pockets of money. So I would suggest that you look into those other avenues of potential sources for business funds that may actually be grants and not necessarily loans as well. Okay, so PPP monies that were funded have to be used during the 8-week period. You permitted to reduce employees' salary hours in order to buy more time. The 8-week period, as far as I know, is pretty set in stone. So once you get the loan, it just starts a 56-day clock. And so your use, and we can talk about this, we might have a slide that actually goes through the formula for the day of reckoning as to what your employee count was during this period of time, and then using it as a go by to see what you had in prior time. And then there's a potential deduct if those numbers are different, meaning that if you have had a reduction in your workforce in comparison to prior periods of time, there's a ratio that is multiplied, and that's on the forgiveness side. That's not on the loan side. Again, we're talking about what happens down the road. So in answer to that, you're permitted to reduce employee hours in order to buy more time. It's a set period of time, and there's not an extension of that period of time.
So this is a question. It appears to come from a nonprofit organization, so relating to being self-insured for unemployment benefits and the $600 being federally funded. We assume you're a nonprofit that's elected to be a reimbursing employer in lieu of paying state reemployment assistance taxes. We assume this because only certain entities can be a reimbursing employer. This is an option available to nonprofits, governmental entities, and Indian tribes. Reimbursing employers will be billed directly for benefits paid to its former employees on a dollar-for-dollar basis, but that will not include the additional $600 benefit. The CARES Act also provides that the federal government will cover 50% of the benefits subject to reimbursement. This federal reimbursement is paid directly to the state, and we would expect it would be credited to your reimbursement payable to the state. unemployed or partially employed individuals should make claims directly to the Florida DEO, which will pay out any benefits to that the employee is eligible to receive. The employer does not pay any benefits directly.
This is Jan Pietrowska. This is, I guess I landed with this question. Here in Florida, just based upon our workforce, we don't do a lot of union work. For those on the phone, the question is in regards to companies that hire union workers from individual halls, who's responsible for the Family First leave payments? So I was just explaining, I don't do a lot of union work, but that's the beauty of being a multi-state firm. Our Ohio partners do a lot of union work, so I gave them a call about this question. Their short answer is that the definition of an employer under Families First, it would include the employing entity. So you, the company, would be responsible for the Families First leave payments for those union workers. There is a provision under Families First that sets up an alternative where you can make a contribution to a Taft-Hartley plan. But in talking to my Ohio partners, they basically said that those plan administrators in the union are taking the position that this is an employer duty. Most of those Taft-Hartley plans don't even have paid sick leave set up under them. They're normally just for some general short-term disability benefits. And the union and the plan administrator's position are the employer is the only entity here who can get the tax credit for paying out these benefits. So uniformly, it appears that this burden is falling on the employer, not on the union or their associated plans. If you need more information on this, the person who sent in this question, please just email me and I will put you in contact with our Ohio partners.
All right, this is John Burgess. I'm going to tee up this question since you may need some background for this. What we have here is a company that's owned by an employee stock ownership plan. That's what ESOP stands for. An ESOP is a qualified retirement plan, just like a 401k plan or a defined benefit plan, but it invests primarily in stock of the company. So I know in this case, the company is 100% owned by its ESOP. And the company makes contributions to the ESOP in order to pay for the stock that is ultimately allocated to participant accounts. So the question here really, it's specific to an ESOP, and it's asked in that context, but it can also apply to 401k contributions. And what happens a lot of the time is that employees will accrue service throughout a year, and then a contribution will be made to fund that benefit that they've earned in the next year. So, for example, in 2019, if employees work the minimum number of hours, which can be up to 1,000, and they're there at the end of the year, they'll get an allocation of a contribution in the plan, and that's usually funded in 2020. So the question here just evolves around how do you measure that contribution when you're looking at PPP? My understanding is that contributions for benefits can be used for PPP purposes when you're looking at the forgivability of the loan. So the question really revolves around: are you looking at this sort of on a cash basis, or are you looking at it on an accrual basis, where you're looking at what's earned in 2020 versus what's paid in 2020? And so I'm going to throw it over to Jack to talk a little bit more about that.
Yeah, it's an interesting question because there's so many things that go into for example, the valuation, the value of the stock at the time of the transfer, or within the plan itself, and what does the plan provide for, and things like that. So the theory is that you have the background theory behind all of this is that the government wants to provide funds for you to continue on operating your business as if it were normal as much as you can. And so, having said that, you would think that, okay, if it were the appropriate time to address an ESOP issue, then that may be okay. Now, I will say that, for all of us at Shumaker and anyone who's dealing with the SBA and the PPP and the IDL and everything else, we'll wake up tomorrow morning and something else will have been changed. and something that has been in force, or the rule the way it has been for 2 weeks, will have been changed or maybe interpreted, or provided further guidance. So, and I think this is one of those things, because if you think about it, what if I can think of two scenarios. One where you have a company that is on a like a June 30th fiscal year, where it would have been normal, maybe end of year, for them to do something in relation to an ESOP or a discretionary bonus or something like that. What happens in the scenario where you have an employer who accelerates an otherwise payable obligation that may have been a third quarter or fourth quarter obligation? So I don't think that the IRS and the SBA, Treasury, and banks are gonna let people get away with that, so to speak. I think that will be addressed, but they're so busy trying to get this next set of money out into your hands that they're really, they know that they have this day of reckoning down the road, but it's not going to happen for a while. So they're kind of hedging their time a little bit to deal with more pressing issues, but there will be more interpretation, I believe, down the road as to what these kind of things, as far as forgiveness, use of funds, etc.
Sorry about that, guys. Didn't realize I was on mute. Are you required to pay the emergency paid sick leave 2 weeks, and also the additional 10 weeks of expanded FMLA to employees that meet the guidelines but not request the eligible FFCRA tax credit? The answer is yes. Whether or not you claim the tax credit or plan to claim the tax credit, as long as you are under the 500 employee threshold, and as long as the employee meets one of those qualifying reasons for either paid sick leave or expanded FMLA, you are required to provide the leave.
Okay, so the common problem is that you ask for this money, hopefully you're getting some of it or will get some of it, and now you're struggling with the fact that your business is not up to speed and will not be up to speed. So you have a couple choices. You can bring your employees back and perhaps have them twiddle their thumbs and do nothing, and get paid for doing nothing. And is that equitable for your business and having received this money? I think from the government standpoint, they're saying, yeah, maybe it is equitable, in a sense that what we're doing is we're providing money to you as a potential grant, meaning not have to be repaid, in order to provide income to your workers, potentially former workers, if you bring them on board. So from that perspective, yes, that even if there's not work for them to do, that maybe you bring them back on board. There is a countervailing perspective in that, well, if unemployment may be a better option for them. And yes, there are scenarios where you have employees that are on unemployment that might be financially better off in continuing on being unemployed and receiving the extra $600, et cetera. I think that in talking to or listening to the regulators, that their perspective on that is, well, do they want to continue their benefits, other benefits, so being furloughed potentially, or being reduced hours, partial unemployment. So you have those considerations going back and forth. And so it's a matter of what is best for your business, but I don't have a magic solution for you that, if you get this money, but you're really not going to use it for a legitimate, that's kind of a harsh word, use it for an efficient purpose in paying employees when they have nothing to do because your business isn't ramped up. So you do have the requirements of the 75% you do have an 8-week period. Now, keep in mind that we're talking about if you use it for proper purpose. So let's say that you are going to use it for rent or something else. So you still have the opportunity, if you don't meet those parameters, to still potentially keep the money. It's not forgiven, but it's a low interest loan where you have payments that you don't have to start until 6 months after the loan was given to you and repaid in 2 years. So, or give the money back. So you have options. And a couple of pieces of advice I would say to you is, first, get all the money that you can, and then decide what you need to do with it. Secondly, the money that you do receive, keep it separate from your operating account so that you can show, again, on the day of reckoning, what you did with the money. And if you're going to give some back, or if it's going to continue into that low interest loan. So again, I don't have the magic solution to deal with the fact that you're not fully operational. We get it, we understand it, but money is really meant to provide money to your workers so that they can get through this period of time. Yes, the 8-week forgiveness period, and I don't know if we can put up the chart that I sent at the last minute. I happened to find a chart that, and I can't take credit for it. It was actually the Memphis Chamber that published this, but essentially there's a ratio that you look at. You take the maximum loan amount, and you assume for a moment that 100% of that is forgiven, that you met all the rules, you did everything that you're supposed to do. You did it with, you provided within the 75% parameters, you used it for all proper purposes, you used it within the 8-week period of time. So it's 100%. There are 2 scenarios where that may not be the case. And so what they're going to do is, again, understand the concept that these monies are meant to be for people to get paid to get through this time. They need a benchmark to look at, and they look at one of 2 periods of time, and they say, okay, so, and I don't know if that can be blown up a little bit. I think on your own screens you can probably modify it, but you basically take the maximum, the base number, the maximum eligible forgiveness amount, which is essentially your loan amount in theory, and then you multiply it by a ratio, with the numerator being the average number of full-time equivalent employees. We're talking equivalent employees, so there's a formula mixed in there that it could be part-time employees that end up being a full-time equivalent during the covered period, which is the 8 weeks, okay? And then you take the average number of full-time equivalent employees per month during the choice period. And you have the 2 choice periods are from February 15th, 2019 to June 30, 2019, which is basically, it's meant to be the similar period of time of the look back for 2020, when the loan proceeds, when you're looking at if you were in business at that time, or if the number works out better for you under certain circumstances, or if you were not in business at that time. Then you look at the first essentially 2 months of this year, January 1st through February 29th. Yes, it was a leap year. And so that is your ratio. So it is a potential reduction. Now, if you're the same number of employees during the cover period, and you can't exceed the loan amount. So you can't, it can't be more than 100% or, a 1/1 multiple. The point of this is that if you did not get up to full speed with your employee core during the time period, then you are not going to get the loan forgiven for that amount. And again, remember that it's not that it's a penalty that you have the money. You can still keep the money potentially. It's that money now becomes a loan and not a forgivable grant, forgivable loan. And so that's deduct number 1. There is another part of it that if you have decrease someone's salary in excess of 25% during the most recent full quarter during when the employee was employed. Now, that's a mouthful, but basically what it's saying is that if you have reduced someone's salary significantly over this period of time, and you're using that number as kind of the base number for that employee, then that may be problematic if there's a deduct for that. So it gets complicated a little bit into the formulas of it, but that's the point of it. And so there are actually, I've seen loan calculators out there. Some of them are being pushed out by banks, some of them by CPAs, that it's a spreadsheet and you put in your numbers. Now, I would say that, validate the numbers, validate the formulas to make sure it works, because obviously there's all kinds of disclaimers as to whether or not it's a good spreadsheet or not. But some of the ones that I've seen seem to work in theory. I've not plugged in the numbers, but they seem to have this fundamental formula within that. So just a few pointers on that. Hopefully it helps walk you through a little bit of the calculation on how you get to that potential shave off of forgiveness. Again, the forgiveness part of it, not necessarily the fact that you have to give the money back or that you now have money that it's improper for you to have that money to begin with. Okay, and this is sort of related to what we talk about wage reductions. So it goes back into that formula as to the loan forgiveness. And there is, on the SBA website, there's some guidance in relation to that. And in some of our publications on our website, there's guidance for that goes into how you calculate those wage reductions. It's a 25% number. Okay, so the question is that you got the money, you complied with the 2 months, essentially the 8 weeks, 56 days, however you want to calculate it, and then you release all your staff or work for someone else or retire if the practice does not return to what you consider an acceptable level. So I say this with a caveat that there may be more to come on this with respect to getting to the finish line of the 8-week period and then what happens after that. As it stands now, and I'm happy if any of my crew wants to correct me on this, but my understanding is that it will, it's the measurement period. So what happens after that, then it's to be determined. And that if the reality is that some businesses are not going to survive through this, even with the loans and with the help. And so, if that becomes the reality down the road, the government's not going to, I don't think, is going to force you to stay in business when you can't stay in business, when it's not financially viable to stay into the business. So, but, is there going to be some sort of tail end responsibility that if you got this money that you can't just dump your core of employees, that there has to be some sort of progression or good reason or some validation for that? I have not seen that. I wouldn't be surprised if maybe that happens, or maybe what happens is that with this additional money that's coming out, are there additional strings attached to that go beyond the 8 weeks, whether it's in this next set that hopefully has occurred by now and been authorized, or if there's going to be another set of money that comes down the road as stimulus funds. And I believe this question relates to the 1099 income as far as independent contractors go. And again, welcome input from others of my colleagues on this call, but initially it was either allowable or questionable whether or not independent contractors were going to be part of the employee mix. And in fact, I know when we have clients that went ahead and submitted with that being part of their information, and there's gonna have to be a correction to that, whether it's on the forgiveness side or kind of at the day of reckoning. But If this question is basically saying that, can you slide 1099 independent contractors into the mix of PPP money? I think there's two considerations. One is that independent contractors they are eligible for PPP money, but they have to do it on their own. They can't be part of an employer. And so, they're under the same, I believe, under the same kind of rules with respect to use of funds and forgiveness of funds. But I don't know, Chris, if you have, or someone else has some input on that, or Jan.
No.
Okay.
All right, so this is Chris Cavalieri again. This question essentially asks, can we push back on an employee who's told us that they are the only suitable person who can take care of a child if we have reason to believe that maybe their spouse in the past was able to watch that child? The answer is it's sort of unclear how much we can push back. So here's what we know. We know that under the Families First law, we can ask the employee, in fact, we're required to get the employee to certify and to sign a statement certifying that there is no other suitable person to watch the child, okay? So I would hope, even though as a lawyer I'm a little cynical, but I would hope that the employee would not lie when they sign that statement certifying that there's no suitable person. If we have a reason to believe that they might be lying, that's where the gray area is. And the gray area being, how can we push back? The regulations make clear that unless it's a piece of information that's required to be asked of the employee, we can't ask the employee for anything else, right? So the regulations make clear that we can ask them to certify that there's no other suitable person, but they don't say anything about being able to ask for additional proof. The IRS guidelines kind of make this even murkier because the IRS guidelines say that the employer, you, can ask for, quote, written support for why the employee needs any type of Families First leave. The problem is that the IRS guidelines don't tell us what that written support is. So I would say that without guidance specifically allowing you to push back, it would be pretty risky. Does that mean you can't ask the employee for clarification like, hey, employee, I thought that your spouse was able to watch your kid a year ago. What's changed? I don't think anything prevents you from asking that question. I just would be very careful before you start requiring a satisfactory answer because you could be walking into a claim. Next question, please. Should we use the regular FMLA designation notice and submit that to the employee? Any other suggestions on forms to be used? So first of all, when it comes to any other suggestions on forms to be used, I would say first and foremost, as soon as an employee puts you on notice that they need paid sick leave or expanded FMLA leave, I would say that the first step that you should do is to give them the request form. And we have two separate forms, one for paid sick leave and the other for expanded FMLA leave. That should be step one, is to have the employee fill out a request form. So there's no question on anybody's mind as to whether this employee is requesting leave under the Families First statute. Step two is, okay, if you're otherwise covered by the FMLA, your question is should we send them the FMLA, the normal FMLA paperwork, the notice of eligibility, the designation notice? The answer is that the regulations do not require it, but we would recommend that you do it for a variety of reasons. First of all, for consistency purposes. Remember, expanded FMLA is just a different type of FMLA leave. And as we're about to get into in a second, to the extent someone uses up their expanded FMLA, it counts toward their normal FMLA for the normal 12-month period. So for consistency, also sending the employee the normal FMLA paperwork if they've got their own serious health condition or if they're caring for a family member with a serious health condition, it will give you the ability to get more information from their doctor because you'd be able to get a medical certification that way. Also, number three, it gives you an opportunity to remind the employee that to the extent they're going to take expanded FMLA leave, it's going to count toward their regular FMLA leave. Next question, please. Do we have to provide paid leave for someone who is at high risk and we cannot provide any other reasonable accommodation for them to be in the facility and they cannot work remotely? The short answer is probably not. And remember, the question is about paid leave, okay? So the short answer is that you're probably not required to provide paid leave based on the way that you've worded this question. So let's unpack that. Number one, you only have to provide paid leave under these coronavirus leave laws if one of those 6 reasons exists. They're subject to a government order, a doctor quarantine order, they have symptoms and they're seeking diagnosis, they're caring for someone under a quarantine order, they've got childcare reasons, or they've got a substantially similar condition, whatever that means. If they don't fall within one of those 6 reasons, you're not required to provide them paid sick leave. And if they don't have childcare issues, you're not required to provide them expanded FMLA leave. Now, having said that, even though you might not be required to provide them paid leave under the Families First laws, you might need to provide them with a reasonable accommodation if they are at high risk and if their doctor has said that they're at high risk. Now, your question says that they can't work remotely. Remember, we are now dealing with the normal ADA reasonable accommodation process. So step 1 is, can we provide a reasonable accommodation in their existing job? If the answer is that we just can't do it, in your case, if the person just can't work from home, or if it's going to be an undue hardship for the business to allow the person to work from home, well then remember, we have a duty under the ADA to try to see if we can reassign them to an equivalent position that might allow them to work from home. Right? And if you can't find an equivalent position, we have a duty under the ADA to see if we can reassign them to a lower level position that would be able to help them perform the job. If you can't do any of these things, last resort is that you might need to consider providing them with a temporary amount of unpaid leave under the ADA as a reasonable accommodation. Next question, please. When someone is out sick or watching their child on FMLA, does this protect them from any layoffs that are occurring while they are out? The answer is no, as long as the layoff would have happened regardless of whether they took the leave. The regulations make clear that employees can be laid off while they are on leave, but here's the rule when that happens. If you lay the person off or if you furlough them while they are on leave, you still have to provide them with their paid leave benefits all the way up until the point where the layoff occurred, right? Because that's paid leave that they were entitled to. They hadn't been laid off yet. The moment that they become laid off, going forward, their entitlement to paid leave under the coronavirus statute expires. Next question. Got lots of great questions on the Families First leave laws. We have several employees who have provided letters from their physicians recommending that they self-quarantine due to medical conditions that put them at greater risk for COVID-19. We've honored these requests. We've paid them paid sick leave. Do we have to allow them to remain at home indefinitely? When they do return, can we change their status from full-time to part-time? So there are a couple of things that we need to unpack here. When we're talking about do we have to allow them to remain at home indefinitely, that goes back to that reasonable accommodation question that our analysis that we went through before. I would say that if this person is able to work from home and if they're requesting, it's unclear from the question whether they're requesting to work from home, but if they're able to work from home and if they're requesting to work from home as a reasonable accommodation because of some disability that puts them at greater risk, I would say the safest route is to, of course, allow them to work from home. It's probably a reasonable accommodation. Again, if this is not possible or if it would present an undue hardship, as we just discussed, let's go through the analysis of whether we can put them into an equivalent position that will allow them to work from home, and if not, a lower level position. And finally, unpaid leave is something that we might want to consider, temporary unpaid leave until the pandemic expires. When it comes to reducing their hours, unfortunately, both the paid sick leave law and the expanded FMLA leave law require that you restore the employee to the same or an equivalent position. That means the same number of hours, same benefits, same everything, right? Or equivalent everything. So the answer is we really can't reduce their hours in general. Now, I will say that the regulations make clear that an employee is not protected from employment actions that would have occurred regardless of whether they took leave. And the regulations use layoff as an example. They don't say anything about reducing hours. I would say that there's a potential argument there that if economic conditions are such that you are going to reduce this position's hours anyway, there's an argument there that you can do that and the employee is not protected from it. Again, a little unclear. I'd like to see more guidance from the DOL on that issue. Now, keep in mind when we're talking about if the person is taking EFMLA, there is an exception to restoring that person to the same or an equivalent position if they're a key employee or if you have under 25 employees and all those conditions exist that we went over before. Next question, please. Okay, one of the employees on paid sick leave also used FMLA for this same condition earlier in the year. Do we count the days he's missing now towards his previously certified FMLA? If so, can we also reduce his hours when he returns? Or are we obligated to return him to the same position? So let's unpack this. The first question here is, can we count the paid sick leave that they've taken toward their FMLA 12 weeks? This is going to depend on whether the person is taking expanded FMLA and their paid sick leave concurrently. What do I mean by that? Remember, paid sick leave and expanded FMLA are two separate things. You've got 2 weeks of leave under paid sick leave. Under the expanded FMLA, you have 12 weeks of leave, the first 2 weeks of which are unpaid, but the employee can use their paid sick leave to substitute that pay during the first 2 weeks. If the employee is only taking paid sick leave and not expanded FMLA leave, then that leave is not going to count toward their 12 weeks of regular FMLA because they're not taking FMLA. They're only taking paid sick leave. But if the employee is taking paid sick leave and expanded FMLA at the same time during those first two initial weeks, then we can count the time that they've spent on paid sick leave for those 2 weeks toward that 12-week entitlement. I hope that makes sense. I know that's a little complicated. Now, as far as reducing hours, again, regardless of whether the person is on paid sick leave or expanded FMLA, the regulations make clear we have a duty to restore them to the same or an equivalent position. The same analysis that I just went over before stands, which is that you might be able to reduce hours if you would have done it regardless of the fact that they took leave. And then there's a potential exception only under expanded FMLA for key employees, and if you've got under 25 and you meet those additional requirements. Okay, next question, please. Our company is under 50 employees, so the FMLA does not apply to us. The regular FMLA does not apply to us. With that being said, am I interpreting it correctly that the expanded FMLA does apply to us because it's for companies under 500 employees, whether or not the regular FMLA applies? Is that correct? The answer is yes. Now remember, there are two potential exceptions here. Number one, you can deny both types of leave, paid sick leave and expanded FMLA, if your employee is a healthcare provider or an emergency responder. And number two, you can deny leave when you qualify for the small business exemption. That again, that's under 50 employees and for childcare reasons, and your authorized officer needs to make a determination that one of those three conditions exist. Other than that, there are no exceptions.
So this is Jan. So the question here is, to what extent can we inquire about an employee's health or their contact with others without violating any HIPAA regulations? The short answer here is this is less of a HIPAA question than it is an Americans with Disabilities Act question. HIPAA can apply to employers in certain situations, but remember, HIPAA addresses the disclosure of medical information. The Americans with Disabilities Act addresses when you can ask employees for medical information. So the general rule under the Americans with Disabilities Act is that an employer cannot, except in very rare exceptions, make medical inquiries of your existing employees. However, with the pandemic, a lot of those regulations and guidance have been loosened, and the EEOC has a coronavirus page where they have frequently asked questions and they address a lot of these issues. Basically, the EEOC has loosened or given permission to employers to make medical inquiries related to coronavirus issues now. So one, when this all started, we all were looking back at the 2009 pandemic guidance and guessing that with coronavirus, employers would eventually be able to do temperature checks. That has been officially sanctioned by the EEOC now. So that is one medical inquiry that you can do. You do have to be careful with and how you set it up, though. There are a number of considerations you have to take into account. Fair Labor Standards Act may come into play. It's likely that the time that the employee is waiting to have their temperature taken and the time that they're having their temperature taken, that's probably compensable time that you may have to pay them. There is confidentiality issues both with HIPAA and the ADA, and so we can't reveal medical information to other employees, so you have to be careful how you set up your temperature check stations. We can't be revealing to other employees that this person does have a fever, so you probably have to do it in a private location. There may be OSHA issues in how do you protect your employee that's having to screen all of these employees. They may be considered to be at medium risk, and you may have to provide some personal protection equipment. The EEOC has also specifically authorized employers to ask employees or screen them for coronavirus symptoms. And so those initially were fever, cough, chills, sore throat. The EEOC subsequently came out and said, look, you should also rely upon the CDC as to what symptoms you can be asking about, and they specifically expanded it based upon CDC guidance that you can ask about a loss of taste or smell or gastrointestinal issues, because those have been identified by the CDC as potential issues. The EEOC is also officially sanctioned requesting doctor's notes from employees who've been out for coronavirus issues, clearing them to return to work. While the EEOC has approved that, the CDC is still cautioning employers that this may overly stress a medical system, or this may not be available, and they should look for other solutions. So next slide. So this question deals with what is our liability if we learn that one of our employees has had exposure to someone that's tested positive. Again, I direct you to the EEOC coronavirus page. They've got a lot of FAQs that are very helpful. They address this one in a broad-based way. The EEOC says employers should be guided by the CDC's guidance about how to bring someone that's been exposed back to work. The CDC's guidance says that we can have employees that have been exposed return to work, and they define someone that's been exposed as someone that had either household contact or was within 6 feet of someone that tested positive, either while that person was symptomatic or in the 48 hours before the person that tested positive had symptoms. The CDC's guidance is that you can bring that employee who was in close proximity back to work if you do a number of things. First, if that employee themselves develops symptoms, you're supposed to send them home. However, the CDC says so long as they don't have symptoms and you take the following steps, you can have them continue to work. One, the CDC is recommending temperature checks of at least those employees that have been exposed prior to they start their shift. 2, the CDC is recommending that the employee with the exposure wear a face mask at work for at least 14 days after having been exposed. 3, the employer has to make sure that the employee social distances, that is, they are at least 6 feet away from all other employees while working. And 4, the CDC is requiring that the employer set up a system of cleaning and disinfecting to make sure the common areas that that employee may be coming in contact with are regularly cleaned and sterilized. If the employer can't comply with those requirements, there is the risk then to the employer, and probably the solution there is, if we can't meet all those requirements, that we have the person that's been exposed be on self-quarantine. We're coming up on 4:30. We're going to try to work through a couple more of these questions. I know that everyone's hanging on, trying to hear their question answered. And so we'll go as quickly as you can, but if not, we'll try to answer everyone's questions afterwards the best we can. So this one also is mine. What considerations should we expect when people start returning to work? Expanded safety considerations, etc. This is a great question. You're right, this will end. People will return to work, and now is the time to start planning for that. We all got sort of hit in the face with the coronavirus issue, and we all had to scramble. Hopefully we can start working on the return to work now. There's a number of things that you can do already. This is both a legal and an operational issue. So the first one is we're going to have to plan for what part of our workforce is going to come back, right? And so you may recall one of our very early client alerts on coronavirus, we did an FAQ from employment law perspective. And in there, we provided, the EEOC approved a questionnaire that you can send out to your workforce to find out about coronavirus complications. And so it asks about, are people going to have a difficulty coming into work because of childcare issues, public transportation or transportation issues, or disabilities? Now, normally you can't ask an employee if they have a disability, but this form designed by the EEOC just simply asks the employee to let us know if one of the 3 conditions are going to prevent them from returning to work. Therefore, we're not specifically asking them if they're disabled, and the EEOC has approved the use of this form. This is going to allow you to do some advanced planning. Who will be able to come back, who won't? So now I can tell what parts of my workforce may be deficient, which ones will be fully staffed, and that'll allow me to move forward. The EEOC also, again, on that FAQ page has indicated that you can ask people now that have disabilities, what reasonable accommodations will you require when we reopen? So again, you're not going to go to an employee and say, do you have a disability? We're going to send out a general notice, maybe in connection with that questionnaire, to all of our employees and say, to the extent that you have a disability, please let us know what reasonable accommodations you need now. So then we can engage in the interactive process, figure out, is it an undue burden to grant that accommodation? Are there alternative accommodations, so that we're not dealing with those issues when we're ready to open and we need people? We can deal with them now while we may not need them. The other issues we're going to have to deal with are personal protective equipment. This is a chance for me to again tout the coronavirus resource page. Just yesterday, we published a client alert on OSHA's PPE requirements. They published a 36-page document defining the type of PPE that employers should be providing their employees. And so you go to our resource page. It's one of the top 2 or 3 client alerts right now. From that client alert, which talks about the PPE that's needed, you can also click the link and go directly to the OSHA guidance. As to what other things we'll have to consider in return to work, we're going to have to deal with, as Chris went through also, ADA reasonable accommodations. We're going to have to deal with employees not wanting to return to work, either because of safety concerns or expanded unemployment. We'll have to work through all those issues. The last thing that I can think of about returning to work is, remember, if we terminated employees and we're rehiring them, that's a rehire. We, like Brad said earlier, we're gonna have to do new I-9s. We're gonna have to do new background checks if that's part of our regulatory coverage. Also, something employers may miss, your restrictive covenant agreements. If you fired someone, their restrictive covenants have started running. And when you bring them back, they will not automatically reset. So you will need to have them sign new non-competes, new non-solicits, or what will happen is the old ones will slowly expire in the back, and then you won't have any. So with that said, we are probably, I don't know, unfortunately, I can't see how many questions we have left, but I think some of our people have had to sign off already. So I think at this point, we appreciate you all showing up. And what we will do is take the rest of the questions and assign people to shoot you some answers. And I know some questions, I've been trying to answer them as they've come in. We'll circle back on those. Thank you very much for attending. We really appreciate it. We do miss our in-person seminars, and we'll be doing those again. We're here to help. Let us know how we can help you. Everyone stay safe out there. We'll get through this. Thank you, everyone, for coming.